Okay, we want to get started. I want to welcome everybody here this morning. Thank you for coming. My name is Liam O'Connell. I'm one of the co-managing partners in Nutter, and I'm the former chair of the Labor and Employment Group. Down on the far end, Chris Lindstrom is our present chair of the Labor and Employment Group. Next to him, Emily Fox, who's a partner in our group. Natalie Capilazzo, who's one of our valued members here of the Labor and Employment team, and to my closest to me is David Rubin, who's also a partner in the Labor and Employment Group. We're delighted to welcome you all. To those of you that are clients, we thank you for your business and the confidence and trust that you place in us. We hope that we'll have an interesting and informative program here today on accommodations for pregnancy, disability, and religious accommodations in the workplace. We have left some time at the close of the presentation for questions. So if you have questions, we certainly want to entertain those and make this as interactive as we can. We are filming this by Zoom. You won't really be on the Zoom, it'll be the panel, but I just wanted to let everybody know that in case you happen to ask a question. You might have your question on Zoom. We're not providing legal advice, as you know, directly on any specific issue here today, but to the extent that you have questions that come out of this, if we can help you in any way, I'd encourage people to reach out to whomever you may know as members of the Nutter team. So with that, I'm going to turn it over to David to get the program started, but thank you again for being here today.
Thanks, Liam. I guess the controls are up there, is that it?
Yes, right here, David.
All right, so I'll stand up there. Move that through. Hello, everyone. David Rubin, as Liam has pointed out. The way we're going to talk today, this is us, obviously. It's my newest picture. I no longer am 28 in my picture. I might have been a mistake.
Keep that one.
So our agenda today, the way we've organized it, first, Chris is going to talk about the recent Supreme Court decision on religious discrimination and accommodations. Then Natalie is going to talk about the new federal law on pregnancy accommodations, pregnancy discrimination. And then Emily gets the gem of a subject, which is the various leaves available and how they interact, whether it's FMLA, PFMLA, state law leaves, and how it all interacts with the ADA. A lot of these subjects really start to blend together, I think you'll see as we talk through this. And so we've divided it up, so probably about the first half hour or so, we'll talk about these first three bullets, and then the second part of the discussion, we'll set it up as a panel for questions among ourselves and for all of you. If you have questions at any point, either during someone's presentation or during the panel, by all means, let us know, raise your hand, and we're happy to address them. I think that's the best way that these programs work, is we sort of have this as a dialogue and a discussion. So with that, I'm going to turn it over to Chris to talk about Groff v. DeJoy.
Thanks, Dave. Morning, everyone. Thank you for coming. So, religious accommodations, it's an area of law that for the first couple decades of my practice, I rarely ever had to touch. I think I probably dealt with it once or twice in the first, as I said, almost 2 decades. But under Title VII of the Civil Rights Act, for religious practices, an employer must provide a reasonable accommodation to an employee who requests one to account for a religious practice, unless that accommodation would impose an undue hardship on the conduct of the employer's business. That's the quotation from the statute. And for 40 years, this was read by courts to mean an undue hardship would be anything more than de minimis cost to an employer. So what does de minimis mean? It means something trivial or insignificant or minor. So as you can imagine, for those 40 years, it was pretty low bar for employers to have to get over in order to prove that providing a certain accommodation to an employee who's requesting it would be more than de minimis and therefore an undue burden, and therefore the employer didn't have to provide that accommodation. And the courts that construed this de minimis standard, you based it on a Supreme Court case from, like I said, 40 years ago, in the 1970s, late 1970s, about that used that exact language and that exact quote, de minimis. So it was in this context that religious accommodations came to the forefront a little bit more in 2021 and 2022, when a lot of employers had COVID vaccine mandates. And as we saw with the COVID vaccine mandates, we received, clients of ours, who then came to us with questions about it, received a lot of requests for accommodations to not have to take the COVID vaccine, either because of a medical reason, perhaps there's an allergy or something to that effect, or more often, we saw it was for religious reasons. And there were a number of employees who requested an exemption from that mandate because for whatever the religious beliefs that that person had, said that they could not take the vaccine, either because of the way the vaccine was developed or other reasons. But it was, again, the standard was a de minimis standard. And therefore, a lot of employers did grant exemptions, especially if the employees were working remotely, like so many were during those first couple of years of COVID, and maybe even today. But for some employers said, we really need to enforce this vaccine mandate, either because we have government contracts that require us to enforce it, or because we have customers who, for instance, want to require our salespeople who are going to their premises to be vaccinated. Or often they had coworkers within the organization that said, I'm not coming back in unless I know everyone else is vaccinated. So the advice typically that we were providing to clients was, in religious accommodations, there are two steps. There's one, does the employee have a sincerely held religious belief of X? And the second part is, would granting this accommodation be an undue burden? We found that in many circumstances, it would be the second step, the undue burden, that it is more than de minimis to the employer to grant the exemption to the COVID vaccine. We never really, I don't think I had a single client who really pushed back on, is this a sincerely held religious belief? As you can imagine, that is rife for problems, especially because the standard under the statute, and as read by the courts, is it doesn't have to be an organized religion. It could be an individual's religious belief that is separate and apart from, whatever, the church, temple, synagogue, mosque, or wherever they practice. So that was the context until this past summer, when a Supreme Court case came out called Groff v. DeJoy. And the circumstances of that case were that we have a gentleman by the name of Gerald Groff who lived in Pennsylvania, and he worked for the United States Postal Service. He is an evangelical Christian who said that he could not work on Sundays. So, for those of us old enough to remember, most of our lives, USPS did not deliver mail on Sundays. Perfect job for him, right? Well, in 2012 and 2013, the Postal Service was asked by an up-and-coming company to start delivering their packages on Sunday. Anyone want to guess what that company's name is? Amazon, exactly. So Amazon and the Postal Service, they sign a contract that says that the Postal Service will now start delivering their packages on Sundays. So, as you can imagine, this became an issue for Mr. Groff. And so the Postal Service then had to negotiate with their Postal Service union to set up a formula whereby they decide who was going to make these deliveries on Sundays, and it was based on seniority, also based on who would volunteer to do it on Sundays. But where Mr. Groff was stationed, they were going to have to do a lot of deliveries, and so he requested a transfer to a more rural location of the Postal Service in Pennsylvania, where they still were not going to have to make these Sunday deliveries. So everything's fine for the next 4 years. Then, as with everything in life, Amazon encroached And Amazon started having to make deliveries from this rural postal service office in Pennsylvania, which meant Mr. Groff was now going to be required to make deliveries on Sunday. He said no. And so what the Postal Service had to do with that location was have other people take up his Sunday deliveries, but they also started disciplining him, and they started giving him progressive discipline. Now, it didn't get to the point where they terminated him, and I wonder if they ever got to that point, but he said, hey, I'm being harassed by this discipline, I quit, and a couple months later, he sued for religious discrimination because they didn't grant his accommodation of not working on Sundays. The reason they didn't grant it was because the Postal Service used this de minimis standard, and they said, this is an undue hardship to us because we are being forced to require all your other coworkers to pick up more Sunday shifts, which makes it harder on your coworkers, makes it harder on our business, and therefore we're not allowing you this exemption. District Court, there were different Supreme Court justices at the time. The District Court in 2019, they said, the Postal Service wins. This is more than de minimis. We agree. You can't burden the other coworkers, and therefore this accommodation was rightfully denied. It gets all the way to the Supreme Court, and as I said, in this past summer, the Supreme Court came out a different direction. Justice Alito wrote the opinion, and he said that the de minimis standard, we never meant that 40 years ago. Even though we let all the lower courts kind of use that standard for a long time, we never meant that. We're going to clarify it. And we're going to say that it's no longer a de minimis standard because it doesn't really make sense. Because if you think of the language, an undue burden, any burden is going to be de minimis. So what does this undue adjective mean? There's got to be something more to it. And so they speak, but of course they didn't give us the exact standard we have to use now. But they did speak in terms of the burden's got to be excessive, or it has to be something more significant than de minimis. And so the quote now is that the undue burden requires substantial increased costs in relation to the conduct of an employer's particular business. So the court emphasized that this is a very fact-specific inquiry. And for those of you who, are HR professionals, GCs that deal with accommodations in the disability or handicap scenario, you know that you have to make a very fact-specific inquiry. What is the accommodation this person's requesting? What is the position they're in? How are we going to be able to accommodate this without really throwing our business off? We're going to have to start doing the same thing now for religious accommodations. The court said that the following were not undue burdens, like temporary costs or occasional shift swapping for employees or administrative costs. So if it's going to cause HR professionals to have to do more, that's not going to meet the undue burden standard. So what do we do now? As I said earlier, we now have to undertake we always did, but since the standard is much higher now, we got to really take a case-by-case analysis with the key questions being, how big is your business? If the U.S. Postal Service, where I think they said they had, 600,000 employees, but that can't be right. It's going to be a lot harder to meet the undue burden standard. But if you have 26 employees, maybe it'll be easier depending on what the request is. You got to account for what the specific request is. What is the impact on your overall business as opposed to coworkers? So the Supreme Court said specifically, I'll take the not working on Sunday or Saturday context. Just because other coworkers are going to have to work those days more, that's not sufficient to meet the undue burden standard. So, but then it gets into, well, what if you have 25 employees and 23 of them are requesting the same thing? Maybe it does become an undue burden because it's really going to impact your business. Temporary or moderate administrative costs, like I said earlier, no longer meet the undue burden standard. And what we're thinking is going to be most important is that you're going to have to document exactly what you did in your analysis. So, how is this going to negatively impact the business? So again, if we think of the COVID vaccine scenario, is the person a like I said earlier, a sales representative who's going to a customer's account. Is it going to impact that customer account for you if that person is not vaccinated? That's the type of analysis you have to do, rather than if it's, if it's accountant who maybe is in the back office and maybe doesn't even come in, is working remotely. It's going to be a different analysis for the vaccine scenario. And if it's, if you're a plant or if you have to shut down a line, for a couple hours because you can't get enough people for a certain shift, I'm thinking some scenarios where people need specific amount of time during the day in order to pray or something to that effect. So you also want to be considering alternative accommodations. See if there's something else you can do that's going to be less burdensome on the company, but still is working with the individual. So you're going to be engaging in that interactive dialogue just like you would do in a handicap or disability context. But it's still a different standard, of course, than the handicap or disability context. The quote is always, it's a significant difficulty or expense to grant the accommodation. Is that the same as, substantial increased costs in relation to your business? Maybe, probably, but we don't know until the courts start construing this. And so, but, the question now for many people is, for many employers is, in the vaccine context, we saw a lot of very legitimate claims for accommodation based on sincerely held religious beliefs. I had many clients who said, we've never heard of any of this before from this employee. We're concerned that he or she is making it up, which is both a shame for the employer and also a shame for those who have sincerely held religious beliefs, obviously. And so the question will be if employers are going to push back a little bit more at that first step in terms of what can you request to see if an individual actually has a sincerely held religious belief. In the ADA accommodation context, it's a little easier. You can get a doctor's note. It's pretty straight, not always, but sometimes straightforward. But here, again, where it doesn't, someone's religious belief does not have to be connected to an organized religion. So a lot of times we saw some letters from religious leaders on behalf of people getting an accommodation. You don't necessarily need that here because a person could have their own belief that is separate and apart from what their religious leader, if they have one, believes. So you're again going to have to tread very carefully in terms of requesting what information. You probably can get the employee to put something in writing. Sometimes when people put something in writing rather than orally say it, they think a little bit more about it. But beyond that, it's going to be interesting to see how much you can push back. But the bottom line is the minimum standard gone completely. And so we're going to have to do a more rigorous analysis whenever you get an accommodation for a religious practice. And whether that's the, as I said, Friday, Saturday, Sunday not working, whether it's relating to facial hair, whether it's relating to any type of uniform exceptions, things like that, we're gonna run into some interesting issues, I'll put it that way. I'll turn it over to Natalie.
Thanks, Chris.
Pull this stuff down.
All right, hi everyone. My name is Natalie Capolazzo. I'm going to be talking about the new federal Pregnant Workers Fairness Act. So the Pregnant Workers Fairness Act is a new federal law that requires employers to provide reasonable accommodations to a worker's known limitations related to pregnancy, childbirth, or other medical conditions, unless the accommodation will cause the employer an undue hardship. So as we said, there's a lot of overlap among these topics. Covered employers in this context are those with 15 or more employees. And one thing worth flagging right off the bat is that the definition of a known limitation is a physical or mental condition related to, affected by, arising out of pregnancy or childbirth. And the condition does not need to meet the definition of a disability under the ADA. So that's definitely worth keeping in mind, that it could be some other condition that wouldn't necessarily trigger the need for an accommodation under the ADA. And that's sort of consistent with the stated purpose of this new law, which is to fill in some of those gaps between Title VII, the ADA, the FMLA, to ensure that it's almost like a catch-all for protections for pregnant workers. And just sort of another point to flag on the related to, affected by, or arising out of language when it comes to medical conditions that are covered. In looking at the examples provided under the proposed rule, I think we can assume that this is going to be pretty broad. So the examples cited in the proposed rule included everything from appointments related to seeking treatment for postpartum depression to time spent undergoing IVF treatments to sort of the more run-of-the-mill conditions that come along with pregnancy, such as fatigue, back pain, like the day-to-day issues. But again, just looking at the proposed rule, it seems that that's going to be pretty broad, so it really can be any condition related to pregnancy or childbirth. Some examples of accommodations that the EEOC has provided include the ability to sit or drink water, closer parking spots, flexible hours, uniforms and safety apparel that fits and is the appropriate size, additional break time, leave time, and exemption from strenuous activities or exposure to chemicals that would pose an increased risk in pregnancy. You may request documentation as the employer, but doing so must be reasonable under the circumstances. And one interesting point in the proposed rule on this is the EEOC recognizes that for a lot of pregnant people, there's a delay in actually accessing medical care. So a lot of healthcare providers won't even see you until you're a certain number of weeks along in the pregnancy. So the EEOC is pretty clear that you should consider granting interim accommodations even if you're waiting on that documentation because of that lag. So for instance, if a pregnant employee has morning sickness early on in the first trimester but isn't able to see a healthcare provider until several weeks later to get that documentation, you should consider granting like an interim accommodation until so that the employee then has time to get the documentation. Under the new law, it's unlawful to require an employee to accept a specific accommodation without an interactive process between the employer and employee. And relatedly, it is unlawful to require that the employee take leave if there's another accommodation that would allow the employee to continue working on the job. And then denying a job or some sort of employment benefit to either an employee or an applicant based on the need for an accommodation. I just flagged that because this does apply to applicants for employment as well. Nothing really new there, but worth mentioning. And then just, again, sort of a catch-all, unlawful to retaliate against or otherwise interfere with rights under this act. And a couple of sort of practical enforcement considerations. The EEOC already has started to accept charges under this law in June, and the notice of proposed rulemaking was already posted back in August, and public comments are due October 10th. So we can expect a lot more guidance to come once the regulations are implemented. And then this sort of just raises the issue of what to do in Massachusetts, particularly because Massachusetts already has its own version of the Pregnant Workers Fairness Act, which was enacted in 2018. Similarly prohibits discrimination against employees due to pregnancy or related conditions. A little bit of a different sort of posture in that this, the federal act is really focused on accommodations, whereas the Massachusetts Act falls under the general anti-discrimination statute in Massachusetts, 151B. So with that, the definition of covered employer is 6 or more employees, so a little bit stricter than the federal counterpart. And one thing that I think is worth flagging here as well, the new federal law expressly says that the pregnancy-related condition doesn't need to rise to the level of a disability under the ADA. We don't have such explicit guidance saying the same thing in Massachusetts, but I think we can assume the same is true because the MCAD's guidance on this reference morning sickness, lactation, certain conditions that require accommodation that sort of, similarly wouldn't necessarily rise to the level of a disability under the ADA. So we should assume that under the Massachusetts law, those sort of other conditions still do need to be accommodated. Same thing requires employers to provide reasonable accommodations using the undue hardship standard. Cannot require an employee to take a specific accommodation, and just like the federal law, employers cannot require that the employee take leave if there's another accommodation that would allow them to continue working on the job. And then one other point that I just wanted to bring up, sort of practically speaking, there's an express prohibition in the Massachusetts law on requiring documentation when it relates to one of these sort of, run-of-the-mill, sort of common sense accommodations, like more frequent breaks, seating, limitations on lifting more than 20 pounds, and then private space for expressing breast milk. These are all conditions where an employer in Massachusetts cannot ask for follow-up documentation. So just sort of like a practical point on that. And I think that basically covers sort of just generally the new act and then what we're already doing in Massachusetts and where they diverge. So with that, I will turn it back over.
You want to flip the slide down one more? Thanks.
And with that, I'll turn it over to Emily.
Put this way down. Can everybody hear me? Okay. All right, cool. I'm Emily Fox. Good to see all of you. I recognize some of you in here. So I'm going to talk about one of my very favorite topics, which is leave entitlements. These are not new. These have been around for a very long time. But I get so many questions about these. We thought it would be a good idea just to kind of revisit it because they're repeatable issues. They're going to come up in your day-to-day work. So there are a lot, as you know. We're going to talk about the Family and Medical Leave Act, state family and medical leave entitlements, and the ADA. But as you know, there's also workers' comp, there's state sick leave, there's short-term, long-term disability. We're not going to talk too much about them, at least in my part of the presentation, but absolutely in questions how they kind of interact with what I'm about to talk about, because that comes up a lot too. How does all of this work together? So first I'm going to run through what I think like the three main buckets of leave entitlements: FMLA, which we're all very familiar with. Covered employers are have 50 or more employees. Eligible employees are those who've worked for the employer for 12 months, who've worked 1,250 hours in the last year, and then at a location with 50 or more employees within 75 miles. And you may have run across this recently with all remote employees. Like where do they count? Are they covered? And the guidance has been you consider where they report into, where they receive assignments from, and if that location has 50 or more, that employee will be entitled to coverage as well. Duration of leave is it's generally 12 weeks. That's typical. It's for most of the reasons in a 12-month benefit year. As you know, there's, I think, 4 different ways to calculate a benefit year. Most people do rolling back, but that varies. And then it can be up to 26 weeks for military caregiver leave. Reasons, we're all familiar with these too. To bond with a new child after birth, adoption, or placement. To deal with an employee's own serious health condition or that of their family member. And then there's a few reasons related to the military qualified exigency leave. So if you're going, just kind of taking care of your family matters, and then military caregiver leave. Like all of these statutes, there's job protection provisions. So for the FMLA, you have to be returned to the same or equivalent position. It doesn't have to be the exact same position, but it has to be almost exactly the same pay, the same benefits, same seniority. And then so that's been around for a long time. We all know the FMLA. The many states, 9 states, and there's 5 more coming this year or next year, have state family and medical leave entitlements. I think a lot of us here are Massachusetts, so we're now all familiar with the Massachusetts PFML, which I'll talk about in a second. Those leaves run concurrently with the FMLA. There's a couple states, I think there's 3 now, that have sick leave entitlements that, there's sick leave entitlements, but they can be for any reason. For example, Illinois just enacted one that employees get 40 hours to do whatever they want. The state leaves are often slightly different from FMLA, federal FMLA, different eligibility requirements, often longer lengths of leave. Many of them offer partial wage replacement benefits and have stronger protections for retaliation and job protection. And then I have this here down at the bottom. In a lot of ways, a request for leave under FMLA or a state leave entitlement is kind of simple. If they have medical documentation to support the need for the leave, and particularly if you have like a third-party administrator who's doing this for you, they give them the documentation, the third-party vendor says like, all good, and they go. They have to go, regardless of how much of a burden it is on your business. And so, that's the case for intermittent leave too, which I know is often a nightmare for clients. There's exceptions to that if you think the medical certification is fraudulent, you have reason to doubt it. But typically it's kind of simple as far as like the decision-making process goes. All right. So as an example, I'll touch upon Massachusetts. As you know, it provides a longer leave period. So not 12, but 20 weeks for employees' own serious health condition. Up to 26 weeks total in a benefit year. And unlike the FMLA, it has nothing to do, your eligibility has nothing to do with service with the employer. It can be with any employer. So as long as you've earned a certain amount of money over the last 4 quarters with an employer in Massachusetts, you can be eligible for the leave regardless of how long you've worked for your current employer. You can actually even be eligible if you're a former employee of an employer, you're not employed at all, as long as if you meet that income threshold. Massachusetts has a partial wage replacement benefit, which I think is a little over $1,000 a week right now. And then I'm sure many of you have dealt with this as it got implemented, that if you don't have a private plan, employees can't top off the partial wage replacement with accrued time. So they can't use vacation, they can't use sick time to kind of cover the delta. Many employers do have their own like family leave policies, which are provide for the delta payment. Nutter has that. Lots of employers have that, which is okay as long as it's under like a family and medical leave policy. Like the FMLA, employees have to be returned to the same or equivalent position. But one thing I wanted to flag, which a lot of people have run into, is there's this really interesting non-retaliation provision in the law that says there's a rebuttable presumption of retaliation if the employee is terminated or suffers some adverse action within 6 months of their return. There's 2 exceptions. One is if employees of similar seniority in similar positions were laid off as part of like a RIF during the course of the leave, and the employee would have been included in that RIF. That's okay, as long as you can show that. And then the second one is if the employer can show with clear and convincing evidence that they would have taken that action regardless of the protected activity. And we can get into that in the questions a little bit, but some situations I think of is if they come back and their attendance is horrible, or they engage in misconduct, or they're not meeting deadlines. You have some documented performance issues where you can show that you would have fired this person anyway, regardless of the use of leave. And so this is my very favorite subject. So we think of, everyone's familiar with the ADA. It covers employers who have at least 15 employees, so the threshold is much lower. And it prevents discrimination against employees who have a disability, qualified employees with a disability, which means they can perform the essential functions of their position with or without an accommodation. And it also requires employers to accommodate qualified employees with disabilities. So, we think of that as like a ramp for somebody in a wheelchair, or, maybe you have braille signs in front of the door, like, some way of modifying the workplace to allow that person to participate and do their job just, the same as anybody else. You don't really think of the ADA necessarily as a leave law. And, I would say that's not really what the ADA was kind of intended to do. But that being said, the EEOC has said that unpaid leave is a form of reasonable accommodation that employers should or, must consider if no other accommodation is available, barring this undue hardship that we've talked about a number of times this morning. And when I think of that, it kind of like doesn't make sense, because the accommodation is supposed to allow them to do the essential functions of their job. And if they're not at work, like, they're not working at all. So how does that make sense? The idea is that this, hopefully short period of leave will allow the employee to recover enough to come back to be able to do the essential functions of their job, perhaps with another accommodation or not. And unlike the FMLA or the state FML, bless you, entitlements we talked about, it's a little mushier, which is a legal term. Leave doesn't have to be granted in all cases. And like any request for accommodation, it has to kind of go through this interactive process that you all are familiar with as far as granting like any kind of accommodation that may modify the job a little bit so they can do it. So even if an employee has the kind of medical documentation that we talked about, you still have to do this case-by-case, fact-specific analysis, and it's not an automatic, like, stamp, yes, you get your ADA leave. So when do we get here? Like, when are we in ADA leave territory? It's usually one of three situations. Where I usually see it is someone's taken FMLA leave and they just aren't ready to come back. So they've exhausted their 12 weeks and they need more time. But it can also be, it wouldn't really be the case in Massachusetts in a lot of situations, but somebody may not be eligible for FMLA leave, or they may not be eligible for Massachusetts PFML, for example, because they were working in another state. Or the employer isn't covered under FMLA. That wouldn't really be the case in Massachusetts, but like a multi-state employer maybe. And so they are covered under the ADA because they have 15 employees, for example. So then once we know where, and I like, when I'm talking to clients, I usually call it like ADA land or ADA territory. Like, if we know we're here, now what do we do? And so it's the same interactive process that you all are really familiar with. You talk to the employee. If you have an employee who's out on FMLA leave and it's, and they're saying, I'm not ready to come back, it's been 12 weeks, you can't automatically say, well, goodbye, we're opening Iraq, your job is gone. You have to consider this at least, leave as an accommodation. And so you're likely going to need medical documentation to support the need for continued leave, and kind of the back and forth. And then it's going to be a conversation with the manager, with the business, with HR, considering the circumstances of the request, the type of position, and burden on the team and operations, taking into account previous leave. So, like, what does that look like when you're kind of engaging in that analysis? Is a little different than, I would say, like a regular accommodation. Can we modify the workplace a little bit? This person's having trouble with the entry system, can we install, a swipe card system? that might be expensive, but you probably have to do it if you're a reasonably sized employer, because expenses is hard. If you're a big enough employer, cost is hard to justify as a undue hardship. But this is a little different. So if somebody's not going to be there, it could impact the business in a different way than modifying the workplace. So, the big one, I think, is the first one, circumstances of the request. Has the person been repeatedly asked for extensions to their leave? So is this it's been 12 weeks of FMLA, they're asking for 3 extra weeks. If that's the case, like, okay, maybe we could just continue this for 3 weeks. But if they've asked for 3 weeks and that 3 weeks becomes another 12 weeks, and then that 12 weeks becomes 5 months, now we're getting into a situation where, like, this kind of feels indefinite. This kind of is really becoming a burden. Our business has changed. We had to restart, whatever it may be. Now it's an undue burden. The doctor's notes, do they indicate, or your notes from Unum or whoever your vendor is, does the doctor say there's a 50% likelihood that they come back in 2 weeks, or is it an 80% likelihood of coming back in 3 months? Is it 100% certain, or what, as close as we can get, that this person's coming back in 2 months? Or is it, you don't see any improvement over the course of these extended requests? And then, of course, like the big one in court cases is how long of a leave is being requested, because the ADA just is not, and I'll talk about this in a second, is not an indefinite leave law. Type of position, is this something where employees can pitch in, the manager can cover, or does this employee have a really specific skill set that only they can do? They are the sales rep for a product line of, like, very specific lasers that no one else can do, and you can't get a temp to cover it because it's, like, a very unique position. Can you get a temp to cover it? Can the manager do it? And then burden on operations. If you can show, we're missing deadlines, we have a backlog, we restructured, and the manager who was covering now is managing 50 other people, and this just isn't working anymore. So all those things are, like, valid considerations when you're considering a request for a leave of absence. And they may not, call it an 8-8 leave of absence. They probably will just say, I need more time. But this is, that's what this is, and this is what you have to do. If ADA leave is granted, unlike the FMLA and state FML, where you can have, like, this equivalent position, it has to be the same position, unless the employee is no longer qualified for it. And kind of just some last thoughts on this. The employers often kind of forget this last step. If you're in a position where you've decided, you've done this analysis that a leave of absence is an undue hardship on the business, you do have to consider whether reassignment is a possible accommodation. And what that would look like is, and it's very often no. Not a lot of employers have a ton of open recs that you can just kind of slot somebody into, but that is an option. You can put someone in a different role for which they're qualified. When you're looking, start with equivalent roles, but you could also look for more junior roles for which they're qualified. You put them in there, and that's where they come back after their leave. You open the rec for their existing position, and they come back to this new role. And you kind of have to go through that process and document that you've done that. And I like to put it in whatever communication to the employee, just so we have a record of it. As I mentioned earlier, indefinite leave is never a reasonable accommodation. And by indefinite leave, it could be open-ended leave, like I'm just going to be out and I hope I get better. But it could also be these kind of forever extended leaves that you say, without a certain return date, without a likelihood of return, where you say, like, okay, we're in indefinite leave territory, and different courts call it different things. Some people call that an undue burden. Some people say that's not a reasonable accommodation. Some courts say that they're not qualified disabled people if it's indefinite. But for whatever reason, that's not required. And there's been a lot of case law holding that the ADA is not intended to primarily be a leave law requiring these extended leaves. And it's always, as everybody has said here, and in any medical situation, the importance of documentation is huge. You know, from the very beginning, from the first request for FMLA through this whole interactive process, document everything, even if it's memo to file, memo to HR. So you have a, you know, like a complete record in the event things go south and you need to call us. So that's all I have.